Alex here with part 143 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the non-child version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off with, I believe, two motions, one for limited discovery and then one to actually modify physical custody. And in this video, we go into my ex's attorney's opposition to the motion to modify child custody. My mindset at the time, I think, could have been worse. I had, of course, some anxiety because I didn't know exactly how she was going to confront my motion to modify child custody. But one thing that I do remember is after having read her opposition, I felt a lot better than prior to having read it. It's one of the things that I noticed towards the later part of my representing myself is that I started to get a lot better at anticipating the response. And one of the things that I have always thought, since that point is if you read an opposition and you're not blindsided or surprised, that's a good thing, because that would mean that the assertions contrary to yours, the contraventions and all of that would have been what you expected, what you planned for, what you anticipated. That's a video topic, anticipating the response. And obviously, if something like that was going to be fatal to the case, you wouldn't have filed the motion in the first place. So if you file a motion and you get pretty much everything that you expected to get in the opposition, that's a very good sign, because that's, you planned for that. You expected those oppositions or those contraventions and such. So, it doesn't mean you're going to win, because the opinion of the judge, especially where they have such wide latitude as they do in child custody cases, could just not side with you. So you may have this opinion, and based on your assertions and your opponent's opposition, you should win, and the judge just doesn't agree because he has a different opinion, different perspective, and it doesn't matter. You still lost. If you get an opposition and there's something in there that surprises you or shocks you, that's usually not good. If it shocks you in the sense of, I can't believe the lawyer said that, for that kind of situation, I would say watch the video, win at all costs, because you're going to have to get used to that. But if, aside from that, it's a very good sign if you get back in opposition and nothing in there is a total shock to you. So I think with all of that being said, we at this point in time should go ahead and take a look at what my ex's attorney has filed. Here we have my ex's opposition to motion to modify child custody. Standard introductory paragraph. Her attorney introduces herself, indicates to the court that she's representing my ex, and that she is opposing the motion to modify child custody that I filed. Here we have the points and authorities. We're going into the first section, and she wants to discuss the relevant facts. Usually the first paragraph is like a summary, so let's take a look here. Since the beginning of the case, the court has entered no fewer than 41 orders in resolution of my motions. This is a reflection of my litigious nature. You know what? Somebody predicted this. She's not going to confront any of the allegations of abuse and neglect, the fact that all of these teeth are rotting out of his skull. What she's going to immediately go into within the first paragraph is, I'm a bad person because I filed too many motions. And the court has entered 41 orders in all caps. Like, this is the problem in this case. It's not my son's abuse. It's not my son's neglect. It's not the fact that she won't take him to school or exchange the homework packet. It's not the fact that he needed 5 crowns and 2 extractions. No. The very first thing that she wants the court to see is, I am a bad person because I filed too many motions. This is a reflection of my litigious nature and my desire to harass my ex through legal means. Keeping this in mind, I have continued to rehash issues that have already been covered in previous motions and orders. For instance, I continue to attach as an exhibit a 6-year-old That's because it's relevant. This is the police report that we've gone over several times. For the purposes of embarrassing my ex, I originally attached. My reply is going to be wonderful. I already know what I'm going to say on reply, but I won't say it now because the document's going to come up, and that's going to be the best point to talk about the reply. But let's continue. I originally attached the same police report as Exhibit 1 to my reply, filed January 12, 2009. The court initially considered the report when the court granted joint legal and joint physical custody in May of 2009, and I continue to attempt to focus the court's attention on it. Next assertion here is McMonigal versus McMonigal, the events which are not barred. Okay, so she's using a change of circumstances. I've already repeatedly stated that this is wrong. None of this analysis applies under joint physical custody situations in Nevada. If you want to know why the attorney is wrong, please watch my video, Change of Circumstances. So what she's trying to do is say that you have to show a change of circumstances before you modify custody, but this is not true in Nevada when you have joint physical custody. So I don't want to spend too much time on it because it's just not true here. In other states, it might be, and for those people who are in those other states, I would recommend you watch the video, Change of Circumstances. And one of the reasons why I say that it might be, it's because this principle comes from a statute, and Nevada has enacted a statute that controls when it applies. The other states of the union may have different statutes that apply under different circumstances than here. Next section. My motion to change custody rests on 3 flimsy grounds. Okay, guys, so flimsy. So again, for a 7-year-old child to have 5 crowns, 2 extractions, and 2 other teeth that are rotting, that's flimsy, apparently. This goes to win at all costs lawyering, and the judge is not amused by any of this. When the hearing comes, she will lose custody. Anyway, let's continue. Number 1, that my ex does not get along with our son's teacher. Number 2, that the report was made to CPS by the teacher. And number 3, that any problems with our son's dental health is a result of her conduct, none of which amounts to a... What? That's a bold statement. So our son's dental health does not amount to a change of circumstances. Now, I've already stated that you don't have to show a change of circumstances to actually modify a joint physical custody relationship. So this is wrong on its face. But even if you did have to show a change of circumstances, I am not sure how 5 crowns and 2 extractions for a 7-year-old child does not amount to a change of circumstances. And I don't know how the attorney would put her signature on this piece of paper. So this is, I've stated multiple times that attorneys and judges will facilitate child abuse, and you can see with your own eyes in print with her signature attached that here she is saying that 5 crowns and 2 extractions is not a change of circumstances. Think about that, guys. Just the reality of it. Think about, there's a word, the gall, the absolute unmitigated gall that she has to say that this is not a change of circumstances. By the way, she ends up cowering out of this anyway. As soon as I think like within a month or 2, she files a motion to withdraw, and she just abandons my ex. But it's like, you would get the impression that I'm this evil person that needs to be punished and that our son is fine. And then after she files this audacious opposition, she just retreats. Let's go into the next section here. On the next basis of hearsay, I allege that my ex somehow undermined the teacher's authority. Wait, why is she saying hearsay? Again, this is so inappropriate. Hearsay occurs in court. It's an evidentiary rule. This is a piece of paper. This is a brief. We're not actually presenting evidence to the court yet. We're just presenting offers of proof. So why is she saying this? It's like, sometimes I really do think this attorney doesn't know what she's doing. On some occasions, I think she does, and she's trying to trick the judge. And then I read stuff like that, and I'm like, this lawyer doesn't know what she's doing, does she? Hearsay is an evidentiary... you can raise this as an objection to block somebody from introducing evidence into court. But we're not there yet. We're just briefing the court. So obviously, I'm not going to go into court and say, hey, Your Honor, this is what the teacher said. I'm going to have the teacher appear as a witness and testify. And that's not hearsay. So this is very strange to me. Again, I guess it's possible that she knows better and she's just trying to trick the judge, but something like this that's so obvious makes me think that she doesn't know what she's doing. Next assertion here. In actuality, my ex does her best to communicate with the teacher. Okay, so why are we disputing this? This is something that's going to come up in the hearing. So this isn't really, she can say this, but okay. This issue here as to whether it's my ex's ability to communicate or the teacher, this is going to come up in court if she appears as a witness to testify. And then the court would weigh the evidence, weigh the testimony of both witnesses. The court's not going to make this finding based on just this piece of paper on this opposition. We're just briefing the court right now, but the attorney is treating the briefing as the actual hearing almost. That's the impression that I'm getting here. As early as September 10th, 2013, my ex communicated with the teacher, thanking her for the report on our son's behavior, reinforcing our instructions. This is just an anecdotal I guess not anecdotal. This is just one instance in time. It's not really the big picture. She's just plucking, cherry picking situations out to make her look good. Next assertion here is the teacher and my ex continue to communicate about the schooling. What's reflected in so she attaches more emails. Again, guys, this is just you can't really do this. You can't really win a hearing this way because both sides should have an opportunity to bring a presentation to the court as to this issue. And so you can't just attach like 9 or 10 different emails to show all these examples to show, hey, Your Honor, this is what's going on. I mean, at best, she could say, we need to talk to the teacher in the courtroom. But what she's trying to do is actually show that my ex and the teacher get along by attaching all of these various different emails. Next assertion here is that my ex continues to dialogue and support the teacher's efforts with her son. She's spending a lot of time on this issue. It's the weakest issue. She should be confronting the dental neglect first, but she hasn't really dealt with that yet. And it might be because she knows that that's the most damning of the allegations. So here's another giant paragraph dealing with the communications with the teacher. So it looks like my ex is admitting a few things that are pretty serious here. The first thing that she admits is that she has washed out my son's mouth with soap for lying to the teacher and lying to her. She has also admitted to spanking our son 7 times with a plastic spatula. So she's admitting that she's actually struck him with a foreign object. Interesting. I thought she would have denied this, but I guess not. So take this. This is another change of circumstances, in my opinion, guys. I mean, washing a child's mouth out with soap, maybe not, but hitting him with a spoon, she's saying is a plastic spatula. I could have sworn that this was a wooden spoon. We're going to have to take a look at this email when we get down to the bottom of this to see exactly what it is that my ex states in this email. So it looks like she says that I'm citing a statute that discusses excessive corporal punishment that can result in physical or mental injury. I don't know if I cited this statute. I think I found this under the case law. I mean, maybe that comes up on reply. So you guys can see this here where this attorney says that even though I'm accusing my ex of beating our son with a spoon, she says, using this standard, Washoe County Social Services investigated and found the allegations to be unsubstantiated for child neglect. So this here, she can't do this, and the attorney should know better. You cannot use the determination by Washoe County Social Services to preclude me from bringing this issue to the court unless you can show that issue preclusion or claim preclusion applies. This is an attorney who is at this point in time coming off as incompetent to me because she's not actually citing issue or claim preclusion in this. She should be including this as case law. So she should say something like this. Alex, is accusing Monica of corporal punishment. Washoe County Social Services investigated and found this to be unsubstantiated pursuant to case, claim preclusion, or she could say pursuant to blah, 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 issue preclusion. And she should be citing this authority to show how I can't bring this issue to the court because the issue's already been decided. She's not doing that. And that's not good. That's a glaring either a mistake or she knows that she doesn't have any authority and so she just doesn't want to bring it up because she would lose if she did. In any event, if she was actually able to successfully dupe the judge into believing this, I would be able to file an appeal and get it overturned on appeal because this would be a legal mistake that this judge would have been tricked into making. Luckily, the judge doesn't fall for it and she will change custody, so I don't end up having to file an appeal. But I want you guys to know this because this is a pretty common tactic that attorneys will use in child custody cases. They'll use CPS determinations to try and show the court that you can't bring an issue because CPS already made a decision. Really, that's a claim or issue preclusion sort of situation, and unless they can show one of those two things applies, they are committing reversible error. Let's go into the next section. Through November, my ex's teacher continued to dialogue with my ex regarding his behavior. So she's going through more emails that are dealing with our son and his behavior in school. Next assertion here is, as noted earlier, I failed to do myself what I accused my ex of doing, changing the homework packet. And this doesn't even come up in court, so I'm not even going to spend time on it. In addition, my ex must want all parents of what? My ex must do what all parents of forgetful students do. Okay, I see. It's mistyped. Okay. Inquire of the teacher concerning school supplies like a tracker. Okay, so this is just a lot of time she's spending on one of the weakest issues that I'm bringing to the court. What is evident from the email communication between my ex and the teacher is that my ex supports the teacher, etc., etc. Well, why would the teacher file an affidavit under penalty of perjury saying the exact opposite, though? So this is an issue of concern. I don't know why she spent so much time on this. She should have just said that she needed the teacher to come into court and testify so she could cross-examine her on this issue. But she spends all this time writing essays on why what the teacher averred in her affidavit isn't true, which is a really ridiculous approach because it's an affidavit sworn under penalty of perjury and signed by the teacher. So again, this is another thing that makes me think this attorney is incompetent. Let's go into the next section here. In attacking my ex on the issue of our son's dental health hygiene, I act as if the responsibility for our son's hygiene rests solely on her shoulders. This isn't really true. She's trying to say that I'm acting like it's only her job, but it's not true. And the judge doesn't buy it. Let's go into the next section. I give my rendition of the facts with regards to our son's dental needs. I try to spin the facts regarding the dental care to make my ex look negligent. However, nothing could be further from the truth. So this is a good contravention, but she ends up losing in the hearing. So the judge will hear this testimony and reject it, and the judge will agree with mine and the dentist's testimony. The dentist is really the one that destroys her. So the dentist goes in and testifies, and there's basically nothing my ex can do to controvert it. Let's go into the next section here. On September 30th, 2013, my ex did not physically obstruct the procedure and would report to the court that the dentist was not present. Next assertion here. What is clear is that both of us are deeply involved in the care of our son's teeth. How are we deeply involved? She's done everything in her power to prevent this surgery from occurring. It's example after example after example after example of my ex doing everything she could to block this dental care from occurring. This is just... And there's no citation here. There's no citation to even an email here. It's just what do they call it? A bald assertion. The Supreme Court refers to these as bald assertions, where your ex will say something and there's nothing to back it up. No authority, no citation, nothing. It's just, okay, this is what's happening. Next assertion here is my request to modify the timeshare on the basis of relocation to Vegas is premature. This isn't true. There's case law in Nevada that allows you to make a relocation trigger on an event occurring. So she's trying to say that the event actually has to occur before I can move, and this isn't true. I cite some case law that crushes this argument, and the judge actually agrees with me, and she allows me to relocate contingent on an event occurring, which is my graduation from school. The event actually does occur, and the relocation triggers successfully. So this is another losing argument. Next assertion here. She goes into the law. She cites the court's continuing jurisdiction to modify custody and visitation. She goes into the best interest factors. Next assertion here is a modification is only warranted when there's been a substantial change of circumstances affecting the welfare of the child and the child's best interest is served by the modification. So this is LSV Carucci, but guys, this doesn't apply because it's a joint physical custody case. So the first analytical prong here that you have to show a substantial change of circumstances doesn't apply when you have joint physical custody. So again, she's wrong. I believe the case that applies is Truax v. Truax, but I haven't memorized that, so I'm not 100% sure on it. And I don't really figure this out yet until the attorney that I hired takes over the case and lets me know about that. Next assertion here is that the law provides that in determining custody of a minor child, the consideration is the best interest of the child, which is true. Next assertion here. In the instant case, there has not been a substantial change of circumstances. Number one, yes, there has. Number two, I don't have to show that anyway. Next assertion here is that to bolster our case, I have cited events that occurred prior to the last custody order and that are therefore inadmissible and cannot be considered by this court. So if this lawyer was successfully able to dupe this judge into believing this statement, I would be able to also get this overturned on appeal because this is a legal mistake. Luckily, the judge doesn't fall for it, but some judges do fall for this. And in fact, this judge has fallen for this mistake in the past in this case. You can use evidence, evidence that has occurred prior to the last custody order, but you can't use it to show a change of circumstances. You have to show it for the best interest. You can do that. You're allowed to. And if a judge says that that's not true, or if an attorney lies, tricks the judge, etc., you can just get it overturned on appeal. The Supreme Court of Nevada will reverse that decision as a legal mistake. I explain why this attorney is wrong in the video Change of Circumstances. Take a look at that video, please. Next assertion here is that my ex would respectfully request that my words on page 19, lines 9 and 10, describe my own actions towards my ex, vindictive, opportunistic, and not having even the slightest shred of good faith. My exhibits that by inclusion are irrelevant police reports serve to embarrass my ex by the sheer number of motions filed in the case. So again, she spent very little time on the dental neglect. She spent more time on the cooperation between herself and the teacher because that was the weakest argument. I guess that was a good tactic by a losing attorney. Just to spend more time on the dental neglect would actually damage her case more. So maybe it was a strategic decision for her to try and draw attention away from that issue because that is ultimately what causes her to lose custody in the hearing. So the fact that she did that might not necessarily show that she is an incompetent attorney as much as it's showing what I talk about in the video, win at all costs lawyering. And then the other thing that she's doing that is very strategic is she is demagoguing me for filing too many papers. It is a very common tactic for attorneys like this to accuse the unrepresented party who is filing too many papers as being vexatious and harassing. So one of the ways that they draw attention away from the abuse and neglect the child is suffering is to tell the court, look, that person is vexatious, they're filing too many papers. Don't read the papers, Your Honor. Do not read them. Just look at the number of filings. There's 49 filings. He's a bad man. He's evil. Deny the motion, please. If the judge actually reads those documents, they'll find out that abuse and neglect is actually occurring. But this tactic works quite often. So the attorney is doing what frequently works in child custody cases. She is citing to the fact that I'm unrepresented and that I filed too many papers. If you want to learn more about this, I think I talk about it in the video, They Will Never Say Good Things, but there might be a better video that addresses this topic as to why attorneys like this do this. It goes into telling the court misrepresentations that are plausible rather than that are implausible. Because if they're implausible, the court will read into them and ask for proof. But if they accuse you of doing something that is very common, the court will often assume they're telling the truth and they won't even check into it. Next assertion here is, over the course of the case, the court has entered more than 40 orders, etc. So she continues to underline the fact that I filed too many papers. One thing that's interesting is she didn't ask for attorney fees. Usually she does. So it's very strange that she didn't ask for attorney fees in this opposition. Let's continue on. Declaration by my ex under penalty of perjury. And this is my ex swearing that all of the factual assertions in this document are true and correct. Next assertion here, certificate of mailing. This attorney is indicating to the court that she mailed this document to me at my address. Next assertion, or this is the motion opposition notice. We have seen this before. I believe that this indicates that she has to pay a $25 filing fee. Yes, it is. So she has to pay a $25 filing fee to file this opposition. We have a bunch of emails that she's attaching here. I am only going to go through the emails that I have not already gone over. If I skip over an email, guys, as with my previous videos in the My Docket series, all you have to do is go down into the description below, click on the links, download the document for yourself, take a look, and if you think that I should have discussed something in the video, just mention it down in the comments below and I'll do my best to elaborate on that issue. So let's start Exhibit 1. We have an email here from my ex to the teacher. Let's start from the bottom. This might be pretty substantial stuff here. Okay, so from the bottom, the teacher is telling my ex, let's meet Wednesday. She doesn't have duty that day, so she can meet after school. She'll be sending home all the information regarding the field trip. So it just looks like generic communication skills. Oh, wait. Our son was accused of spitting up in the air, and the spit was landing on other students, and they were not happy. He has to also learn to keep his hands to himself. So my ex says, let's see, she says to the teacher, our son has always struggled with understanding how impulsive he is and how he affects others. It's something we continue to work on. Although it's hard to hear about what he's doing, I appreciate you letting me know. If you have the time to send emails with specifics, she'll work with him at home. Let's see if anything in here jumps out at me. I think, wait, what is this here? Another email. Army was in the red at 8:10 this morning, messing around in line. He would run, then stop, let the child behind him run into him. He did it 4 times, kept ziggy-zagging the kids, circling them. It looks like he's just annoying all these other kids. Okay, let's go into the next section here. Exhibit 2. We have rough morning. Well, let's start from the bottom. Is it the bottom? That's the bottom, okay. Email from the teacher to the ex. Little bit of a rough morning. He ended up agreeing great weekend. My ex tells the teacher thanks for letting her know. Let's go into the next section here. He's been doing well for the last few days, keeping his hands to himself, focusing on what he needs to get done. Morning was a different story when he went to line up. Rather than go to the back of the line, a student asked him to go to the end. He did. Then he walked to the back, stood there for a second, then took off running to the front. He ran in between 2 first-grade lines, elbowing every student he came in contact with. He was laughing. Okay, nothing else there. Exhibit 4. What do we got here? She's talking with the discipline coordinator. He needs to have a lunch detention for his actions in the morning. It's his second detention. And then my ex says, phones are down for some reason. Not sure what's going on. And then my ex says, thanks for keeping her informed. He isn't coming to school. She's giving him Tylenol and ibuprofen after his dental work. She tried calling the office, but no one is picking up. Okay. Exhibit 5. What do we have here? Where's the bottom? Okay, starting from the bottom. This is an email from my ex, it looks like. Last year when he was suspended, she was called to come to the office and talk to the discipline coordinator. Has there been a policy change? Because she thinks it helped him take it seriously. The teacher says she wants to reinforce how serious it is. She's not disappointed that she didn't have to... I'm not disappointed that I didn't have to see his father? What does she mean? I'm not disappointed that I didn't have to see his father. Wait, I'm confused. My ex says her fault. She should have added additional information. She called me and I came and got him. Fuber and her discussed with me about his behavior and the reasons for the suspension. The reason for calling me was because she knew that her son was with me, and next time she'll give a call to her as well. Not disappointed that she didn't have to see me. It's like a double negative. It almost makes me think she's disappointed that she did have to see me, but I don't know exactly what she means by that. I guess it's confusing to me, but it makes it seem like she didn't have to see me and that was okay. Maybe my ex was trying to say that somehow it was relevant that I needed to see the teacher that day. I can't remember this incident. What do we have up here? Just to clarify, next time you want to call both myself. Okay, so she's telling my ex, she wants to be clear. Does she want the teacher to call both of us? Meaning the four of us in the room to discuss the situation. And then my ex says she'd like to be called. And then the teacher says the clarification that she needs is if she wants her to come in as a group and discuss the matter. Your email makes it sound like you wanted to be included in the sit down with everyone. Or do you just want a phone call? And then my ex says it would depend on the situation. If I was able to leave work and who was all there, the more staff, the safer I would feel. Safer. It's just such a joke. And the next assertion is, be assured that any time the meeting requires both you and I to attend, I would be more than happy to be there. And that looks like everything. Exhibit 6. So let's start from the bottom. Okay. We have here Mrs. Rada. Army's father didn't have the packet for the week. Is there any way you could put another copy in? That says... Oh, so she's asking the teacher to do stuff. And then the teacher says the new one's in the folder. And then my ex says, thanks. And then my ex says, thanks for coming out to talk to her. Exhibit 7. Okay, at the bottom, today's been extremely rough for our son. He is constantly making sound effects, arguing and playing with his hands rather than listening, refuses to accept the answers no, stop, or don't. Only earned 1 sticker today. He's been doing a better job of keeping his hands to himself and playing well with others. His class behavior has been a struggle, though. The teacher is saying, thanks for letting her know. She talked about it. He was... Oh, no, okay, sorry. This is my ex saying to the teacher he was grounded. We don't use the word grounded. That's weird. Why? What's wrong with that word? It's not an evil word. I usually have a very rough day with him on Sundays, even if she's rewarding him. It's almost easier if he's in trouble because he's calmer when he knows he's in trouble. It's very hard to get him to listen. He's so hyper. If she takes him shopping, she'll have to keep him in a cart, or he ends up crawling, laying down, or doing something on the dirty floor if she's not watching his every move. He obeys whatever she says, but he goes right back doing it 5 minutes later. She's not sure what else to do to motivate him. She doesn't see other kids acting like this. It's too bad that even she doesn't understand how the abuse is affecting him. She also doesn't understand the difference between depression and mania. Mania is one of the things that happens to kids like this whose brains are all scrambled up from the abuse and neglect, as they get manic, and she realizes that he's harder to deal with when he's manic because he goes ballistic. In any event, we don't need to spend too much time on that. Let's keep going. Exhibit 8, starting from the bottom. So our son will be getting a yellow day because of his choices in music class. Music teacher said he was making noises, and then my ex says thanks for the details, and she'll talk to him. Okay, Exhibit 9. Okay, he's on blue. He's been doing a great job. Really proud of him, etc. And then my ex says, thanks so much for saying. She's almost crying. They talked a lot, and then she doesn't know what to say sometimes, and she's hoping she's making an impact on him on how to treat people. Next assertion here is at recess, he had an issue with rough play, hit a kid on the playground because the other kid wasn't playing the game the way Army wanted him to. The teacher approached him and asked him what he did, and he said it was because he was mad. And then she asked him why he was in trouble, and he blamed everything on the other student and didn't take any responsibility for his actions. She told him that he needed to be honest, and finally he said the truth. And she told him that he needed to move his clip to yellow. He's going to lose recess. And as they were walking in from recess, she turned around and he was once again putting his hands on another student. Let's continue. Exhibit 11, scrolling to the bottom. So my ex says, the teacher says, as you know from the email yesterday, she took recess away from him. She doesn't believe in having him lose a full recess, so he got out for 10 minutes, and she regrets that choice because he came into the classroom right after lunch. He stayed for 20 minutes. They discussed why he lost recess. And it looks like that's everything here. And then my ex says she's sorry that he wasn't behaving again. She's not sure what else to do except more of what she's been doing. He hasn't been allowed to watch any movies since yesterday, and they don't have a TV. She took his only electronic game away and won't be letting him have it for the rest of the month. She washed his mouth out with soap for lying. And then she slapped his hands 7 times with a kitchen spatula for putting his hands on another person. Okay, so I think I know now why my ex sent this email to the teacher. She was basically trying to tell the teacher to stop. Okay, guys, this is my theory. And this isn't a theory that I would give you based on a single email communication. This is a theory that I'm going to give you based on all of the years of interacting with her and her attitude towards anyone who kind of criticized her. And sometimes criticism of our son was treated as a criticism of her. I sometimes got the vibe that, and I've said this before, that she would try to settle scores with other people or with the world, and also that she would try to teach other people a lesson. It was very much the way that I felt she dealt with people who offended her, is she would want to teach them a lesson. And to me, a normal abuser who doesn't have these mental health issues wouldn't want to say this because the other person would report them to CPS, which is exactly what happened here. But what I think she's thinking is, I don't want this other teacher to tell me anything else that he's doing. And the way I'm going to convince this teacher is by telling her that I am doing these forms of discipline to him. And interestingly enough, I can remember sometimes when I talked to other teachers and they thought I was giving him some really severe discipline. And I was like wondering, why do you guys think I'm doing those things? In fact, one of the teachers one time came up to me and she was like, I'm really afraid of telling you, what Army's been doing because he says you're going to do all these horrible things. And I'm like, what are you talking about? I guess it was like spanking or beatings or something. And I'm like, none of that's true. And so maybe the same thing that she was expecting would control the teachers from talking to me was the same thing that she wanted to use against the teachers, in this instance specific to her. And it's this idea of, I will beat you, I will beat this child if he's not doing good. And so it's sort of kind of giving the teacher a cue to just stop telling me stuff because this is what I'm going to do to this kid if you tell me. Just stop telling me. I don't want to hear it anymore. Now, some people will say, well, hold on a second. Even an abuser who's got mental health issues wouldn't want to say that because they know that would be reported. Well, not necessarily. High conflict child custody parents, in fact, high conflict people generally actually thrive in conflict. So they don't mind if they are subjected to criminal proceedings, are subjected to disciplinary proceedings. They don't mind if they get reported to CPS. And in fact, why should my ex be afraid of that? Because what did CPS do? They didn't do anything. CPS has shown her that they're not going to do anything to her in the past. So CPS is a really good opportunity for her to get conflict while at the same time not have to face any consequences. If CPS is reported on her, she gets conflict, she basically thrives in that conflict, and then they don't do anything to her anyway, so it's not like she's going to have to suffer any consequence. So, I don't think that this is that ridiculous of an idea. And then, of course, with me, this triggers motions, so she gets conflict in court. So from the perspective of a person who craves conflict, she's getting everything that she wants. She's getting conflict from the teacher, she's getting conflict from CPS, she's getting conflict from me, she's getting conflict from the court system. She's getting what it is that she craves. And so for her to admit to the teacher that she's beating him with a spoon isn't really that much of a shock to me. All of these different dimensions to this one thing that she's doing sort of come to mind to me. I don't know really what else to say I guess I kind of thoroughly covered it, so I'm going to go ahead and move on. Exhibit 12. Okay, so here we have the teacher saying Army is having a wonderful day until he went to lunch. Unfortunately, he made poor choices in the lunchroom. One of the things that he did was take a cracker and rub it on another child's head. The other child didn't like it and asked him to stop, and then Army didn't stop. He pretended to kiss the same student, then turned and pretended to kiss the girl sitting next to him. The girl was beyond upset and came crying. He also ate her sandwich. Wow, he's getting worse. He said that he didn't mean to eat her sandwich. He just shows how much space he dominates at lunch. His food and lunchbox are constantly all over the place. He creates such a mess that he doesn't even know what food belongs to him. Um, Prior to lunch, he was only 2 stickers away from earning a coupon. Judging by this morning, which was great, he was hoping to earn 2 more. However, due to these issues, he will not get anything. He was on green all morning, and then because of lunch, he's red, and she wants him to be successful. She can't reward him today because it would be a mixed message due to the fact that she wants him to be successful. The teacher decided to give him a specific spot in the lunchroom each day, and then he'll eat at a desk by himself until they feel like he can sit with his classmates. And then he also lost recess for the next day. Starting from the bottom. Sadly, he got another red day. He was on red by 9 a.m. The reason he got there so quickly was because he just couldn't control himself. He was making sound effects, being silly, goofy. Lots of warnings, moved the clip down to yellow, and then when they were walking out to PE, he got in another student's face and was acting like he was going to hit his head on the other kid's head. He now has to walk with her when they go anywhere. Once they get back to class, she removed him from class and sent him to another teacher's room. Okay, looks like Exhibit 14. Starting from the bottom. Wait, let's go way down to the bottom. What do we got? It's kind of, there's a lot. Hold on, guys. 1 second. Okay, here we go. So, looks like the teacher is communicating so much. Today is a much better day. They've been very focused and on task. Worked really hard and only needed a few reminders. Okay, let's go to the next section. Yesterday he had a good day, got to green. Today was a different story. He was struggling with his listening skills more than ever. This morning when she was on duty, she had to talk to him as well as another teacher. Ended up having to separate him in the cafeteria. He continued to do all the things she asked him to stop doing. She had him move to yellow after many warnings. Then during math time, struggled with daily warm-up. They both decided in order to be successful, he has to be an excellent listener. 30 seconds later, she started teaching the math lesson. She turned around and he was sharpening a pencil rather than listening. It's almost a daily thing. She's teaching and is doing something else. She's noticing that he doesn't follow all the instructions in his math homework and that it's hindering his work in class. Let's go to the next section. Just to let her know he's in the red, 0 listening skills. She's had to tell him to do something 4 or 5 times before he does it. He'd rather be playing than working. Next assertion. He worked really hard to get blue, got some stickers, and then my ex says thank you. They talked about what kind of day he wanted to have all the way to school. Okay. 15. Let's check the bottom. Okay, here we go from the bottom. So this is a communication from my ex. It looks like she's saying he's coughing badly. She should have just kept him home. They've both been sick. She'll come get him. He didn't sleep last night, and neither did she because the heater broke, and they're hoping that they'll fix it today. It was like 40 degrees, very cold. Okay, and so she's saying, okay, the teacher said that he was on red and that it was an extremely difficult day. They started at 8:45 when he had a cough drop that he was trying to sneak. Okay, I remember getting this one. Something about making popping noises. Anyway, then my ex says he was sick, and then the teacher responds that she hopes he feels better and that he's going to need to miss recess for his behavior. Then my ex says that he was disappointed. She's trying to work with him to understand that She's still proud. Green is good. She found beef jerky that's natural with no preservatives. And the teacher says skills were not as strong. Okay, so that's fine. That's everything here. So let's go to the bottom here. So the teacher says he got blue, worked really hard, stayed, and got compliments from 3 different teachers. And then my ex says, did you keep his tracker? His whole backpack was full of water when he came home, and his homework was soaked with no tracker. The teacher says, nope, he got a star and he put it in his backpack. And that she talked to the tutoring teacher and she doesn't have anything. And that she knows that I just got him a new one last week because he hasn't had one for a week. So he had it yesterday afternoon when he left the classroom. And then my ex says, when she opened the backpack and got home, it wasn't there. And that I never brought the old one back. Something about an old one, claims that my ex has it, which she doesn't. And she says that she, let's see here. I had it when, okay, our son had it when he left for school yesterday and that it wasn't in his backpack. And then he says he doesn't know where this is and maybe you kept it, which usually you don't do. So why is this a back and forth? And then the teacher says that she just found it in the bottom of his cubby under his classroom books. And she explained to him that it's his responsibility to put it in his backpack. That's it. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed one opposition and incurred $25 in costs. I didn't have an attorney yet, so I incurred $0 in attorney fees. My ex's attorney would have spent quite a while on this opposition. It's a 55-page document. I know most of it is just exhibits, but she would still have to spend time reading the exhibits and also referencing the exhibits in the opposition itself, as well as communicating with my ex as to the relevancy of the exhibits. Under the circumstances, I highly doubt that this document took less than 6 hours. It sounds like a lot, but this is really what it comes down to with a thorough opposition like this, especially with a document like this that's really going to be likely to, actually cause my ex to lose custody, and which ultimately does cause her to lose custody. So, I mean, a part of me wants to say 8 hours, but it's just not 8 hours worth of work. And even though I feel bad about 6, I think 6 hours is probably pretty accurate with all of the communication, all the back and forth, all the reading, putting it all together, filing it, serving it. And then, of course, she would have had to read my motion pretty carefully so that she could controvert the assertions that I made in the motion. So I guess 6 hours is pretty fair. 6 hours at the rate of $250 an hour is going to come to $1,500 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.